Hi there, I'm Ken Lammers. Welcome to Cltv. Today we're going to go through, well, what we do at the end of pretty much every week, my Fave 5.
The number you have reached, 911, has been changed to a non-published number.
Hi again, Ken Lammers here. This week we're going to go through my favorite 5 posts of the week. Y'all made it rough on me this week. I got it down to about 12. And then when I cut really tight, I got it down to about 7. And, you know, they had to be a little bit ruthless on the last couple cuts. But I finally did get it down to 5. Now we're going to start out today with Capital Defense Weekly, and Capital Defense Weekly is talking about the Georgia Supreme Court overturning a contempt of court conviction on a public defender who had been, representing her client, and it was one of those situations which you see in juvenile court a lot, where the public defender is saying, "Judge, you seem to have already made your mind up on this, and Judge, I need to talk to my client, Judge," and onward like that. And the judge finds the public defender in contempt. It gets appealed all the way up to the Supreme Court of Georgia, and the Supreme Court of Georgia basically tightens up overturns it or sends it back for to be re-reviewed, but tightens up the rules in the process and makes it clear that if there's any kind of question, it's resolved in favor of believing that the defense counsel is partaking in vigorous advocacy. So I chose Capital Defense Weekly, but that one was in I don't know how many blogs this last week. It was in a number of them. Our second story this week is from Norm Pattis, and he's talking about somebody who called him up. It's a humorous one. I suggest you check it out because I will not do it justice. But somebody calls him up, wants to hire him, and before he can even check his voicemail, calls him back up and tells him he's a scumbag and he'd never hire him. And then again, before he checks his email, calls again and says, you need to cut your hair. And it's better if you read it from him. It's funnier from him. So I suggest you go over and check that one out. Our third is from Of Counsel, and again we're back to Georgia. I don't know what's going on. This seems like all the stories in the last 2 weeks are either Georgia or Texas. For some reason, there's not for some reason. The Texas thing has been obsessive, and Georgia seems to be not too far behind. But what Georgia is about is, Of Counsel is talking about a defendant who wanted to raise ineffective assistance of counsel on the initial appeal, and how the governing body of Georgia's public defenders wouldn't give a different attorney to the defendant. And this goes all the way up to the Supreme Court of Virginia, or the Supreme Court of Georgia, let me say. And the Supreme Court of Georgia says, that ain't right. And says, I don't care what the policy is of the governing body of public defenders. If he's going to claim ineffective assistance of counsel, there's a conflict there, and he has to have a different counsel on his appeal. This isn't a situation. I did a number of appeals when I was defense counsel. It's not a situation that comes up in Virginia, because during the initial appeal, you can't raise ineffective assistance of counsel in Virginia. You have to raise it in a habeas. I will say that I think it's a good idea, in most cases, for the counsel at trial to be the counsel for appellate cases, because counsel at trial will then be aware of and make objections that will preserve things he might not otherwise. And let me say, in difficult cases with difficult clients, counsel, what I used to do was raise some sort of procedural issue and make sure it was preserved on the record so that I could appeal that procedural issue, even if I knew there was absolutely no facts that were going to be really appealable in the initial appeal. And I think that it would be something along the lines of the way the jury is selected in Virginia are unconstitutional, or the way that things are sentencing occurs in Virginia is unconstitutional. And I think that if you are the person in the trial, knowing that you're going to be the person in the appeal, you're in a position to do that. And I suspect that when trial counsel and appellate counsel are different people, that there can be a disconnect, particularly in the lower level cases. But it is good in a state where they do allow ineffective assistance of counsel claims during initial appeal. It's a good thing that they allow, an attorney to be conflicted out and another attorney to be appointed. Our fourth story today is from a public defender, and a public defender, Gideon, is talking about, well, he's coming out in favor of the videotaping of all interrogations from beginning to end. Personally, I'm kind of there with him, and this is from a prosecutor's point of view, because videotaping, whether it be the DUI stop when places can afford to put videos into the cars, or whether it be the interrogation or anything, although I don't necessarily think it has to be video. I think, a tape, and nowadays you can buy digital tape recorders for like $20, and a lot of police officers are doing it on their own just to be on the safe side. But a tape of what's going on 99.99% of the time is going to help the prosecution. It just is, because we all know how many people make admissions during discussions with the officers, and if it's the way it is in most interrogations that I've watched and listened to, there usually isn't a whole lot of arm twisting going on. Now, I understand why public defender thinks that maybe Miranda has kind of been abrogated by the development of emotional and other interrogation techniques, which aren't the old-fashioned, take him in the back room and beat him till he confesses, but still leave the defendant or the offender or the suspect at a disadvantage. I understand why he's concerned about those things, but I still think that in 99.99% of the cases, if there's a tape, it's going to help the prosecution. And so I'm all for him. And finally, we get to simple justice. Simple justice is talking about how the DEA is trying to get involved in drugs, no kidding. How the DEA is trying to get involved in over-the-counter prescription drugs, or maybe not even over-the-counter prescription drugs, prescription drugs, and he's upset because the DEA has been trying to get into determining what schedule certain drugs are, and determining whether drugs should be available for the public and how they should be available. I gotta say, I kind of agree with him on that. I don't really think that the DEA has a whole lot of business determining what schedule something's in, although I understand the frustration, and I'll explain that a little bit. But I don't think they really should be determining what schedule something's in. I don't think they should be determining when and how something should come to market. That's what we have the FDA for, and if it's doing its job properly, we should get sufficient schedules and such out of them. Now, let me say, I understand where this is all coming from. I wouldn't have, in all honesty, before I came out here to the mountains. When I was in Central Virginia, the drugs were, cocaine, heroin, marijuana, and you get something like psilocybin once in a while, or just kind of weird things, but you didn't get a whole lot of pills. And the problem out here, everybody thinks it's meth out in the mountains, And it's not here, although there is some of that, and there's a little bit of cocaine and all that. But the big problem out here is pills. And, you know, you end up, and I understand why the DEA wants to check on doctors and pharmacists and all this. Because, I mean, if you've ever been in court with somebody who got caught, you know, prosecuting or defending someone who's gotten caught with enough pills to kill an elephant, and who walks into court with a script that was written in Tennessee, filled in West Virginia, and this person lives in Virginia, you know, which is all possible here, and this is not a terribly uncommon scenario. You really realize that, you know, maybe some doctors need to be watched a little bit closer, and some pharmacists need to be watched a little bit closer, because they will go pretty far to get these things. Now, there's another issue too with mail delivery drugs and people chasing down UPS trucks to get their drugs because they know the delivery is supposed to be coming, that sort of thing. That's a whole other problem. But getting back to where we started at, I understand why the DEA has problems with the schedules. For instance, we have a big problem with Lortab, which is a Schedule 3. Huge problem with the abuse of Lortab. It's just rampant. And because it's Schedule 3 and the Schedule 3s are punished lower and all that, it's not really dealt with as well as, say, an Oxy, you know, or something along those lines. It definitely not dealt with as well as heroin or cocaine is. But it's a massive problem. And so the thought process would be, you know, move it up to Schedule 2, and therefore you can deal with it in an appropriate manner. I understand that thought process. I don't know that it's correct. I think that what the correct way of handling it would probably be to change the laws to say, you know, and in the case of Lortab, XYZ, much like marijuana. You know, marijuana is not scheduled in, or in, you know, at least in Virginia it's not, and it has its own separate set, you know, of laws, which are, you know, crafted for marijuana rather than placing it in with the other drugs. I do want to touch on one other thing that that Simple Justice brings up. There's a couple of, and he didn't really bring these up on his own. They come from the article he's talking about. There's a couple of you know, boogeymen that are raised. First is that, you know, if the DEA does these sorts of things, well, then doctors might feel constrained from writing script. And the second is that if the DEA gets involved, well, then companies won't be, you know, will be hesitant to get into the drug business because, you know, if they're in drugs and the DEA might say, no, you can't sell this, well, then they could lose all their money put into it. I don't buy the second one at all. Too much profit margin. Too many companies heavily invested already into, you know, development of drugs. I just don't see that. The first one, you know, I really ain't got a whole lot of issue with that. If a doctor thinks twice about what he's doing with drugs, and, you know, I don't know how prevalent it is. Obviously, if you work in the courts, your view of the world is skewed because you only see things that are going wrong. But, you know, as far as I can tell, and I'm not the guy who handles the drug cases for our office, not Benny at least, but, you know, it seems like there's a lot of guys handing Oxy out like it's candy, and Lortab, and Xanax. Those are the big three that I remember hearing the names of mostly in court, hearing a lot in court. So, you know, if the doctor thinks twice about that, maybe, you know, we won't have as much of it out on the street. It has been an issue around here. I got to say, you know, I did a lot of time, a lot of work around Richmond, and I didn't see too many people dying from overdoses. I mean, there's a lot of heroin and cocaine being traded and all this stuff. There wasn't a whole lot of overdoses. There have been overdoses fair number of overdoses since I've been here, and that's leads me to make a totally anecdotal, unstatistically informed conclusion that in the end these pills are more dangerous, or at least they're more deceptive and can be more dangerous because of that. I think having more control on the pills would be a better thing, would be a good thing. But that's just me. And having said my 2 bits for this week, I think I'm going to sign off. Hopefully next week, ladies and gentlemen, we'll be up again with a couple of new posts, and we'll see what tickles my fancy next week. Y'all have a good week now.